The Premier of Ontario and former Solicitor General do not need to legally comply with the subpoena issued to them by the Commissioner of the Public Order Emergency Commission, and I have the judge's ruling to share with you. Tamara Ugolini here with Rebel News to provide you with an update as I had previously reported on the Monday, November 1st federal court hearing when lawyers representing Premier of Ontario Doug Ford and his former Solicitor General turned Health Minister Sylvia Jones on why they were justified in invoking parliamentary privilege to evade testimony at the federally legislated Public Order Emergency Commission that is currently taking place in Ottawa and will continue until the end of this month.
I believe there's also someone in court today attacking one of the subpoenas.
Basically, the lawyers for Ford et al. Argued that one mere day of testimony would distract the parliamentarians from their parliamentary duty, and to force either to comply with the subpoena issued against them would result in irreparable harm. Ford was recently questioned about this during question period. Have a listen.
Mr. Speaker, this is a federal inquiry into the federal government's use of the Federal Emergencies Act. From day one, Mr. Speaker, for Ontario, this was a policing matter. It was not a political matter. This is a federal issue. We've had our senior public service go there, the deputy. We've had the commissioner of the OPP there. This was under the police. I don't direct the police. This is something that falls under the police. The OPP sent police officers there and they ended it. And so it's a federal government, it's not a provincial government.
The lawyer representing the Ottawa Residents Coalition said that referring to this socially important inquiry as an inconvenience or a distraction would be a grave shame, while the lawyer for the commission highlighted that there is no legal precedence that exists on invoking privilege in the context of a commission, especially one of such great public importance. The judge repeatedly wondered if the parliamentarians were invoking privilege as a sword or a shield. And once again, the Doug Ford government takes unprecedented legislative action with apparent immunity, as the invocation of parliamentary privilege will indeed shield Ford and Jones from legal consequences of not providing testimony to the commission. It's high time that immunity from scrutiny and criticism ends for our political class. All across the country, politicians appear increasingly out of touch and out to lunch on our dime, and we know that the general consensus from Ontarians is that Doug Ford should testify.
Your legal representation is arguing, Premier, that you testifying would cause irreparable harm. Can you tell us today what that irreparable harm is, sir?
You know, I guess that's legal talk.
That's why we've launched a petition at stophiding.ca that urges Doug Ford and Sylvia Jones to uphold their parliamentary duty and testify, not hide behind it. Yet Judge Simon Fothergill did not see it that way and granted Ford and Jones their motion, in part. Basically, he did not stay the summons, but he did provide legal immunity shall Ford and Jones cling to the apparently constitutionally protected notion of parliamentary privilege. See, it appears that some have more constitutional rights than others. This was despite the fact that on October the 11th, counsel for the commission clearly communicated why the testimony of Ford and Jones was being sought after, and I will quote. On October 11th, it was stated that the commission remains of the view that their testimonies are important to its fact-finding mandate and that there will likely be important gaps in its record if they do not testify. Should these gaps remain, or should the evidence of other parties raise the possibility of adverse findings against them, the Commission may consider issuing summons if Ontario does not come forward. For now, the Commission will stand by and see how the evidence unfolds. We will get back to you on this issue if necessary. A week later, on October 18th, the Commission Council stated that they were not satisfied with the province offering up two senior provincial officials. That was former Assistant Deputy Minister of Integrated Policy and Planning Division with the Ontario Ministry of Transportation, Ian Freeman, and Mario D. Tomaso, Deputy Solicitor General of Ontario, as they are not members of Ontario's Legislative Assembly. Have a look. On the question of Ontario politicians' choice not to participate in the tripartite table, Mr. Di Tommaso said during his interview that he could not speak for the politicians on this point. The evidence so far is that Premier Ford told Mayor Watson, that's the mayor of Ottawa, that the table was a waste of time. Why? The other levels of government didn't seem to think so. What is Ontario's point of view? There will be federal evidence that Premier Ford told Minister LeBlanc that he would direct the Solgen to participate in the tripartite table, but she did not. Why? Why did the provincial emergency regulations not target the parliamentary precinct specifically? Why did it not take a conduct-based approach instead of the traffic-based? The federal emergency declaration facilitated a police response, but policing is provincial jurisdiction. The Premier supported the federal public order emergency. Why? Was he not satisfied that Ontario could resolve the situation in Windsor and Ottawa using provincial powers alone? Why? The Commission is grateful to have the perspective of Ontario senior civil servants, but feels it is in the public interest to gain insight into the political choices that were made when faced with the events of early 2022. The Commission will eventually draw conclusions about these political decisions, and it may play to Ontario's advantage if it can express its points of view through its elected officials. On October 24th, the Commissioner issued a summons to Ford and Jones to give evidence on November 10th. It included the words, "This summons is enforceable in the same manner as a summons issued by a civil court of competent jurisdiction, including by contempt of court proceedings. Except that the contempt of court proceedings cannot be enforced now that Judge Fothergill has ruled partially in favor of Jones and Ford." He concluded that the privilege provides the Premier and Minister with a lawful excuse not to comply with the summonses issued by the Commissioner. Fothergill ruled that the summonses issued by the Public Order Emergency Commission are, quote, valid, but as long as the Ontario Legislative Assembly remains in session and the applicants continue to resist the summonses by asserting parliamentary privilege, the Commission cannot take steps to enforce their attendance and compel them to give evidence as contemplated. He did not award costs to any party. If you think Ford and Jones should comply with the Commissioner and testify, as have every other parliamentarian all across Canada thus far, then sign our petition at stophiding.ca. For Rebel News, I'm Tamara Ugolini. If you think Ford and Jones are using parliamentary privilege as a shield rather than a sword, then consider signing our petition at stophiding.ca, calling on these two key players to uphold their parliamentary duty and responsibility to testify. That website again is stophiding.ca.